All right, guys, what you're about to see is a courtroom moment that quickly spirals into a tense legal battle. It starts with a simple claim about diabetes, but within seconds, the judge is already questioning credibility and motives. The defense tries to reopen a plea, arguing medical complications, while the court pushes back hard, setting the tone for a heated exchange that's far from straightforward.
He had a medical consultation quite in depth, and it does show the diabetes he suffered from. And I guess ultimately is this, they're claiming by hearsay police report that he said he wasn't a diabetic when asked on the road, or I don't know where, that they allege. Even if that was true, we deny it, but even if it was true, it's a manifest injustice that he pled guilty, that it was artificially high, his blood alcohol level. So in other words, if DNA is, somebody's convicted of murder, great, and DNA later shows something, well, you know what? It's not a manifest injustice. I understand that that's
Do you have a medical record that tells me, a doctor that tells me that he's a diabetic?
Yes, Your Honor.
Does it say in a report, or am I going to be asked to interpret numbers here?
No. That he's a pre-diabetic. And Your Honor, I'm a pre-diabetic and I have to take a shot of 3 pills every day. So I don't know where they come up with the word pre, but they called me that too. I guess after a certain number, you become a diabetic officially. But I take Ozempic and I take 3 other pills for my pre-diabetes.
I know, but a lot of people take Ozempic just because they want to lose weight too.
It ain't losing weight. Mine was almost going into shock when I was in Chicago about 2 years ago.
Well, if this is a report dated October the 7th,
Right.
what is this
At this point, the defense leans heavily into the argument that the defendant's diabetic condition could have distorted breathalyzer results. The judge, however, isn't convinced, pressing for a clear medical proof instead of assumptions. What unfolds here is a clash between scientific claims and legal standards, where every word is scrutinized and the burden of proof becomes the central pressure point.
dated October the 7th,
Right.
what is this medication that he's on?
What kind of medication?
Metformin.
For what?
Metformin.
What's that for?
Diabetes. I'm on 1,000 milligrams daily for the last 2 years. We had produced last time the prescription history from Myers.
Have you seen this, Mr. Bologna?
I have not yet.
The pre-diabetes. That doesn't mean he's a diabetic though, right?
Your Honor, I'm a pre-diabetic and I have to take the shot.
Why would he have told the police officer he wasn't diabetic?
First, it's a police report hearsay. Nobody's testified to that. And the bottom line is, Judge, respectfully, if they're inaccurate results, that's a miscarriage of justice. If they can't do that test.
Well, wait a minute. You mean I could, if I'm diabetic, I could tell him I'm not diabetic, have him lure him into giving me an intoxilizer, and then come back and argue that the intoxilizer results are invalid because you bought my lie and you relied on it and you didn't get a blood draw instead?
Judge, I doubt very much that he knew scientifically that he can't take the breathalyzer. His attorney didn't know, and it was never brought up though.
Why would a lawyer bring it up when their client?
Now the tension escalates as the judge introduces a critical concern. What if the defendant misled the officer? The possibility of manipulating the system is put front and center. The defense pushes back, calling the report unreliable, but the judge isn't letting go. This moment exposes the fragile line between error and intentional deception, raising serious doubts about the entire argument.
When their client told the officer they weren't diabetic.
Your Honor, that's hearsay right now.
All right.
You're relying 100% that the officer said that.
Well, who are you relying on? You're handing me a police report you're handing me a medical report that says pre-diabetic. You say he's a diabetic. He says he's a diabetic now, even though apparently he told the police. So the police are either lying in a police report, in which case they should be kicked off the force.
Okay.
Who's saying he's a diabetic? This says pre-diabetes. What information do you have to tell me that the lawyer should have pursued that?
Pre-diabetic is like diabetic. That's what I am.
Well, you're saying that. I don't know that to be true.
Making it up.
Well, I don't know if you are or not.
Oh, there you go. Okay.
Well, you guys are coming in now saying there's diabetes involved, and I don't have any evidence of that.
You got it in front of you right now?
It says pre-diabetic. What do you have to say, Mr. Bologna?
Your Honor, if the request is for a Ginther hearing this point, it's focused on ineffective assistance of counsel. All we have to work off is what we have in the report and what was done up until now. The report says that he stated he was not diabetic. So the question is, was there ineffective assistance of counsel? If counsel is reviewing that report, I can only assume that he's not going to ask me follow-up questions as it relates to diabetes. So unless there's something that states where the client presented prior counsel with a statement saying I'm diabetic, or medical records to prior counsel stating that he's diabetic.
Here, the prosecution steps in to reinforce a key point. The entire case hinges on what the defendant told the officer at the time. If the statement was clear, then the defense attorney had no reason to investigate further. The judge builds on this logic, questioning whether any lawyer would realistically pursue a claim that directly contradicts their client's own words.
I think it's safe to assume that there was effective assistance of counsel in this whole process.
His prior counsel didn't even know what diabetes does, or pre-diabetes.
Who said that?
Hearing, I'll have a doctor sitting up there during the Gunther hearing and the former attorney. The results are just, they're void. We can't say, well, you said something to the officer, so we're gonna put everything aside.
Okay, so I just want to ask you this question. If the officer comes in here and tells me, Judge, unequivocally, the defendant told me he was not diabetic, how, and if I believe that officer's testimony, you still think it's ineffective assistance of counsel because the defense lawyer didn't pursue an avenue when the officer had been told by the defendant, according to the officer, that he was not diabetic, and therefore that the defense simply could lure somebody in by saying, no, I'm not diabetic, wink, wink, and then go back and say, I was diabetic, and the results are skewed. I can't even imagine a lawyer trying to argue that his client's diabetic if the officer was told by the defendant, if the officer was told by that, you're right, there are mistakes, that he was not diabetic.
He's got medication with it.
As the exchange reaches its peak, the judge lays out a scenario that challenges the defense's entire strategy. Even in the worst-case assumption, the argument struggles to hold up under scrutiny. The focus shifts to whether the test results should stand or be excluded, and the courtroom dynamic makes one thing clear. This isn't just about evidence, it's about credibility.
And it's on the report, his medication.
Which report? The medical report or the police report?
I believe both.
I didn't ask you that. What report are you referring to? The medical?
That report
The
has,
medical report.
and I'm sure the inventory, and I don't have the inventory report, has what was on it. I don't have an inventory report. I don't.
What else? Anybody else want to help me out here and tell me why I'm thinking incorrectly? Mr. Bologna, Mr. Colovis?
A hearing with results, it'll be a very short hearing.
You're going to bring in the doctor.
I'll bring in his treating physician, not a made up one. And how long he's been on it. So what I'm saying is, let's just say that the officer heard that my client was not a diabetic. Let's just say, does that mean that test results go in? Absolutely not. You got to lay foundation. And one of the foundations is, if you're a diabetic, then you blow.
If you're conceding that he told the officer he was not diabetic, Are you conceding
No,
that?
no, I'm saying what, the worst case scenario, that's. I haven't seen a video.